would like to give a thanks to Corono for the tag. Let's take a look. Rial and Toye reply brief in support for fees. So what's going on here is, yet again, it seems that Monica, Ron, and Lemoine are not happy with what they were awarded for attorney's fees by Judge Chup, and they want the courts to reconsider that award and give them $100,000 more. Basically, it's what's going on. Is that old news? It probably sounds like it because they have been complaining about this since the middle/latter part of 2019, according to my recollection. In this video, we're going to read this part of the document, the brief factual reply. We're going to be reading about 5 pages out of the full submission, which is about 25 pages. I skimmed through this, and most of this is stuff that they have already submitted, which should not really be that surprising. If you remember some of the previous filings from Lemoine, he tends to repeat himself a lot in these filings. I don't know why. It's almost like they're trying to pad the attorney's fees or something. I don't know. Anyways, maybe I'll do a separate video covering some of the funny stuff here, like where they cried about Nick Rekieta again. They seem to enjoy crying about him. But for now, let's get started with the video. Let's read the news. We're going to be reading 1 through 5. Let's go. Summary of reply. The trial court acted arbitrarily and abused its discretion in awarding Rial and Toye an amount of attorney's fees $100,000 lower than the amount proved by competent evidence. They wanted $282,953.80. Evidence of attorney's fees that is clear, direct, and uncontroverted is taken as true as a matter of law, especially where the opposing party had the means and opportunity of disproving the evidence but failed to do so. In such instances, appellate courts will reverse a denial or minimization of attorney's fees and render judgment in the amount proved. They then cite some precedents and claim which reversed a $150 attorney's fees award and rendered a $22,500 award. In this case, let me scroll this a bit, one moment. In this case, Rial and Toye proved their entitlement to the full amount of fees by submitting both affidavits and expert testimony. Well, according to Chup, it sounds like that's really not the case. But that's why they're here trying to, get a new ruling on this. They performed the appropriate lodestar analysis, considered the Arthur Anderson factors, and then applied rumors, billing discretion reductions. Rial and Toye also provided their full unredacted billing records for in-camera inspection, as well as a summary chart to show the calculations and reductions. Now, speaking about billing, wasn't there something really weird on the billing? I forget which defendant it was specifically. I think it was Moron. And wasn't it something along the lines of them claiming to have paid out of pocket at the start, but then they ended up having the attorney for Funimation on there or something like that? Again, I don't really remember what happened entirely because this happened many months ago, and there's been all kinds of shenanigans in the last year and a half involved with this situation and plenty of others out there. But there was something kind of weird going on. I wonder if that will get brought up again. We'll see. There was ample evidence to allow the court and Mignogna to disprove Rial and Toye's calculations or perform their own. They chose not to. Mignogna did not provide any controverting evidence as to reasonable hourly rates, reasonable and necessary expenditures of time, and did not provide the trial court with a competing lodestar analysis, despite having 3 weeks to prepare and present such a challenge. So I would raise the question, even if no one disputed your attorney's fees, wouldn't that mean that, whatever you said should have more merit? And Chup still ends up ruling the way he did? Doesn't that kind of not look good for you, I would imagine? I mean, it's like you got to make your claim without anyone, refuting it according to you right there. It sounds like, or at least Mignogna, according to you right there. And this is still what you got. Doesn't seem like a good look. Seems like a weird argument to me. Let's continue. I get what he's trying to do. He's trying to, make it sound like the law's on his side and all that, but I still find it kind of odd. Continuing. Neither the trial court nor Mignogna offered any analysis at all to support a lower award. Therefore, the trial court abused its discretion in failing to award the full amount requested and proven by Rial and Toye. Now, this is very funny. If you go back and take a look at the other documents that they have submitted regarding, the attorney's fees that they were awarded and how they want more money, you'll notice how every document seems to kind of progress. The first one was pretty respectfully asking the court to reconsider. And then they start getting a little angrier at Chup in the next one. And then this one just, they abused their discretion. I don't know. Again, this stuff's been going on for a while. Maybe I'm recalling improperly, but I don't think I am. Continuing. Texas statutes and case law are clear. To challenge the reasonableness of the amount charged after a proper affidavit has been filed, the opponent must file and serve a controverting affidavit or offer contradictory expert testimony. Okay, there's more precedents right there. Although Mignogna had many opportunities to challenge Rial and Toye's fees through proper evidence, he failed to do so. Why are you repeating yourself? And you're spending more money submitting this document You're spending more money, costing more attorney's fees. Says even during Mignogna's cross-examination of Rial and Toye's fee expert, he never introduced any evidence or undermined the testimony that the hourly rate, time spent, and lodestar analysis were reasonable and necessary. Now for the time on appeal. Mignogna realizes that an expert... Oh, let me scroll this a bit for you. Oh, no, I don't need to. I had the first part cut off. Oh, my goodness. I will edit that in post-production. I'll take a screenshot and post it up there. Anyways, moving on. Now, for the first time on appeal, Mignogna realizes that an expert on fees is required, so his response tries to argue that this court should adopt appellee Jamie Marchi's fee expert, Sam Johnson, as Mignogna's expert. Specifically, he argues that because Johnson testified that $48,137.50 was reasonable and necessary for Marchi, that amount was reasonable and necessary for both Rial and Toye. Now, how many of you remember the transcript where Judge Chupp actually made that argument? Chupp actually said, paraphrasing here, I don't want to misrepresent Judge Chupp, but the point is, he said that it was quite odd that there was such a discrepancy in fees with the defendants compared to Monica and Ron, and especially mentioned that regarding Marchi. And yes, he factored in, to my memory, that the circumstances are different for what they're both being sued for, different causes of action, different merit to said causes of action and damages that they have, caused the victim to suffer. But it's still, even factoring that all in, he pointed out and said it was odd. Paraphrased. Moving on. Says, response, the argument is facially absurd? Factually absurd? Is that what it should say? Mignogna never disclosed, proffered, or adopted Johnson as an expert below, and Johnson specifically testified. Oh my gosh, why is this one gigantic? Okay, let me cut this here and fix this. Okay, this image is huge. I'm just going to let it take up the full screen. It says that he never reviewed Rial and Toye's bills and could not offer an opinion on their fees. Johnson did, however, testify that Rial and Toye's fees were understandably higher because Rial and Toye's counsel had twice the number of clients, faced more factual allegations, and conducted significantly more discovery. In other words, Johnson's testimony actually supports Rial and Toye's position that they are entitled to a higher fee award. Almost like they're buddy-buddy or something. Isn't that interesting? Based on the record, the trial court could have reached only one decision and failed to do so. Accordingly, Rial and Toye respectfully request that this court reverse and render an award of $282,953.80 in trial fees and $55,000 in appellate fees. Hypothetically, let's say that the appeals don't go well for Vic. And let's say that Monica and Ron do get awarded this amount that they want. Despite all of that, I don't think that they will ever repair the damage that they have caused to their own reputations with how terribly they have all handled this situation, in my opinion. Kind of a irony to that, in a way. Anyways, that is the news, my friends. Thank you for tuning in. I hope you enjoyed this, and I look forward to checking out the comments. I think they'll be pretty amusing on this one. I've got shout-outs for the kind people who promoted the two segments from yesterday, the last two segments. Shouts out to Golden Magikarp, The Ice Cream is Just an Illusion, Darren, Ryan, Jill Art, Mojiko, KJC, Kenta, Anime Night 1992, The Dinosaur King, Shon M, Opai Pantsu, Phantom R, David H, Amazing Ronin, Pot on the Brain, Shogun, DXDKJ, Tony D, John E, The Ice Cream is Just an Illusion, Pot on the Brain, Amazing Ronin, Shogun, Nameless Mirko Simp, to Zippos, Gravin L, John E, Joshua B, Deshaun M, and The Dinosaur King. Thank you all, though, for tuning in, and I look forward to catching you next time.